They handed me the termination papers at 4:47 p.m. on a Wednesday. I read every word twice, signed 3 copies, collected my belongings, and walked out. At 2:13 a.m., my phone erupted with an unknown number. The voice belonged to their senior counsel, and he was shaking. "Mr. Hoffman, please tell me you didn't actually sign those documents." I smiled in the darkness of my bedroom. "I signed exactly what you presented to me, Noah. You might want to check Section 7, Subsection C. Terminations based on performance deficiencies require documented performance improvement plans attached as appendix materials. I see no appendices. Your move." My name is Walter Hoffman. I'm 51 years old, and I just caught my former employer in the biggest policy violation of their corporate lives. Before we continue, let me establish who I am and how I got to this point. 27 years in corporate operations management, the last 18 at Apex Dynamics, progressing from operations manager to VP of strategic operations. I started there when I was 24, fresh out of college with a business degree and more ambition than sense. I'd overseen 43 major operational initiatives during my tenure, initiatives that generated approximately $820 million in cost savings and efficiency improvements. I'd restructured the supply chain division, reducing overhead by 31%. I'd implemented automated quality control systems that decreased defect rates by 38%. I'd built the strategic operations department from 8 people to 72 people. For all those contributions, I'd been terminated at 4:47 p.m. on a Wednesday afternoon for consistent performance deficiencies that nobody would actually specify. The thing is, at 51, you start thinking about legacy, about what you've built and what you're leaving behind. My divorce from Linda 2 years ago had been rough. She'd been right about me choosing work over family too many times. We'd been married 22 years when she finally had enough. The irony wasn't lost on me that I'd spent decades building policies to protect employees, yet I'd failed to protect my own marriage. My daughter Emma was in her 2nd year of medical school at Johns Hopkins, costing me $65,000 a year. At 24, she was brilliant and determined, everything I'd hoped she'd become. My son Jake was 22, finishing his engineering degree at Virginia Tech. I needed this job for another 7 years minimum before I could think about retirement. The divorce had already cut my assets in half, and Emma's education wasn't getting any cheaper. But here's what Jerome Walsh and his team didn't know about me. I'd been watching this pattern develop for months. At 38, Jerome was the new CEO with a private equity background who joined Apex 10 months ago. His mandate was clear: modernize operations and reduce legacy costs. I'd seen 3 other experienced managers get fired in the past 6 months, all on vague performance issues, all without proper documentation. The termination package sat on my dining room table at 11:15 p.m. that Wednesday night. 3 identical copies, each one signed with my full legal name, every signature line executed, every initial placed where those yellow tabs indicated. I'd spent 54 minutes reading through all 29 pages of legal documentation that Apex Dynamics had prepared for my departure. The severance terms were mediocre but acceptable. 27 weeks of pay, 1 week for each year I'd given them, health insurance through May, standard non-solicitation and non-disclosure language. What caught my attention wasn't what they'd included, it was what they'd forgotten to attach. Section 7, Subsection C, buried on page 10, between clauses about intellectual property and company equipment return, in cases where termination results from documented performance deficiencies. This agreement shall incorporate by reference all performance improvement plans, warning notices, and evaluative materials relevant to said deficiencies attached herein as Appendix B and forming the factual basis for separation. I'd written that language myself 8 years ago when I'd been promoted to VP. And asked to overhaul Apex's human resources policies. Too many talented people had been dismissed on vague accusations, too many careers destroyed with no paper trail, no accountability, no recourse. I'd seen what happened when companies decided older employees were too expensive and just made up reasons to get rid of them. Back in 2016, I'd watched them fire Richard Martinez, a 58-year-old quality control supervisor with 31 years of experience. They claimed he was resistant to new methodologies but never specified which methodologies or provided any documentation of his alleged resistance. Richard took his severance and disappeared quietly. 6 months later, I heard through mutual contacts that he'd struggled to find work at his age and ended up taking a job paying 40% less than his Apex salary. That's when I knew I had to build protections into the system, protections that required documentation, evidence, due process. protections that required companies to actually prove their case before destroying someone's career. I'd spent 3 months drafting comprehensive employment policies that would prevent exactly what had happened to Richard. Jerome Walsh represented everything I'd written those policies to stop: young, ambitious executives who saw experienced employees as expensive obstacles rather than valuable assets. His efficiency initiatives were really just ways to push out older workers and replace them with cheaper, younger alternatives. But I'd built those policies specifically to catch people like Jerome when they got sloppy. And boy, had they gotten sloppy. My phone lit up the darkness again. Unknown caller, area code 6117 Boston, where Apex maintained their legal operations center. I let it ring 6 times before answering, savoring each ring because I knew what was coming. Walter Hoffman speaking. Mr. Hoffman, this is Noah Parker from Apex Dynamics Legal Counsel. His voice carried a tremor I'd never heard in our previous interactions. At 35, Noah was one of those corporate lawyers who'd never faced a real challenge. Tonight was about to change that. I apologize for the late hour, but I need to ask you something urgent about the separation documents provided this afternoon. I'm listening, Noah. Have you executed the non-disclosure provisions of the termination agreement? I glanced at the papers on my table. My signature on page 22, directly above the NDA section. I signed everything Apex provided me exactly as your HR director specified. Mr. Hoffman, I need you to understand something critical. There may have been a documentation error in the materials we supplied. We're prepared to offer you a chance to review revised paperwork. What sort of error? My voice remained perfectly neutral. Years of corporate negotiations had taught me never to show my cards too early. I'm not at liberty to discuss specifics telephonically, but if you haven't yet executed the agreement, we'd appreciate scheduling a meeting to address certain corrections. I executed all documents at approximately 7:45 p.m. this evening. I scanned the completed package and transmitted it to your HR department at 8:02 p.m. Is something wrong with your documentation? The pause stretched long enough that I wondered if the connection had dropped. Background voices filtered through. Someone was conducting an emergency meeting at Apex's legal offices at 2 in the morning. That told me everything I needed to know about how serious this was. Mr. Hoffman, Noah's voice returned, tighter now. Can you clarify what you mean by executed all documents? I signed the separation agreement as presented, every page initialed where indicated, every signature line completed. The full 29-page document that HR Director Rachel Turner provided during my termination meeting at 4:15 p.m. today. And the appendices, did you review the attached appendices? What appendices? The document I received contained no appendices, just the 29-page separation agreement. Another extended silence. I heard someone curse distinctly in the background. Multiple voices now. This wasn't just Noah working late. This was a full crisis management team assembled at 2 a.m. Mr. Hoffman, the separation agreement should have included appendix materials. Specifically, if termination was classified as performance-based, there should have been performance improvement documentation attached as Appendix B. Should have been, Noah? Interesting phrasing. Because according to Section 7, subsection C of the separation agreement I signed, performance-based terminations must be accompanied by PEEP documentation. Not should be, must be, quote, this agreement shall incorporate by reference all performance improvement plans, warning notices, and evaluative materials relevant to said deficiencies attached herein as Appendix B and forming the factual basis for separation, end quote. Dead silence. I could practically hear him sweating through the phone. I count 0 appendices attached to the document I received and signed. I continued, my voice getting harder. Which means either my termination wasn't actually performance-based, in which case you need to explain why your termination letter explicitly states consistent performance deficiencies, or my termination was performance-based, but you failed to provide the mandatory documentation, rendering the separation agreement invalid because it violates your own contractual requirements. Mr. Hoffman, either way, Noah, I believe we'll be seeing each other in court. I suggest you get some rest. Tomorrow is going to be exceptionally long for Apex's legal team. I ended the call before he could respond. Linda had been listening from the hallway. My ex-wife and I had been talking more lately. Nothing romantic. Just 2 parents figuring out how to help our kids succeed. The divorce had been bitter, but watching Emma and Jake navigate their futures had softened some of the old resentments. You planned this? She asked, stepping into the kitchen. I planned for the possibility they might terminate me without following proper procedures. I wrote those procedures specifically to prevent what happened today. vague performance accusations with no documentation, no improvement plans, no objective metrics. Linda poured herself a glass of water and sat across from me. At 49, she still looked good, though I could see the stress lines that hadn't been there during our marriage. Teaching high school had its own challenges. What happens now? Now we wait to see if they attempt to fabricate documentation retroactively, which constitutes fraud, or claim the appendix materials aren't actually required, contradicting their written policy, or try to settle this quietly before it becomes public knowledge. Which outcome do you want? Honestly, I want them to take me to court. Discovery in a wrongful termination lawsuit would expose how many others they've dismissed using identical tactics. I'm betting that number is substantially higher than Apex wants their investors to know. Linda studied my face for a moment. This is about more than just you, isn't it? This is about what happened to Richard Martinez and the others. She was right. Linda had always been able to read me better than I could read myself. I've watched Jerome Walsh systematically target anyone over 45 with substantial experience and high salaries. He calls it organizational efficiency, but it's really age discrimination, disguised as performance management. How many others in the past 10 months? At least 6 people I know of, maybe more. All experienced employees, all terminated for vague performance issues, all within 90 days of Jerome identifying them as legacy mindset problems. Let me tell you about the termination meeting. It had been brief and uncomfortable. Rachel Turner from HR and Jerome Walsh himself. Jerome had made it clear from day one that he considered experienced employees like me expensive obstacles to his vision of a lean, agile workforce. The meeting took place in Conference Room C, the one with the intimidating mahogany table and no windows. I'd been in that room dozens of times over the years for budget meetings and strategic planning sessions. Now I was sitting there as the target. Walter, we need to discuss a serious matter regarding your performance. Jerome had begun, staring at his notepad instead of making eye contact, already a bad sign. In my experience, executives who couldn't look you in the eye during difficult conversations were either lying or cowards, sometimes both. What performance issues? I'd asked directly. No point dancing around the topic. Multiple stakeholders have raised concerns about your operational outcomes and management effectiveness. After thorough consideration, we've determined your performance doesn't meet Apex's current standards. We're terminating your employment effective immediately. The corporate speak was impressive. Lots of words that said absolutely nothing specific. I'd heard similar language when they fired Sandra Kim 3 months ago and David Foster 2 months before that. The script was becoming predictable. What specific performance deficiencies are you referencing? Which stakeholders? What metrics are we discussing? The specifics are documented in your personnel file. What matters now is transition planning. Rachel had shifted uncomfortably in her seat. At 42, she'd been with Apex for 8 years and had always been professional in our interactions. I could see she wasn't comfortable with this conversation, but she was following orders. I'd like to review that documentation of performance deficiencies. That's not necessary for this discussion. Rachel had interjected quickly. We're prepared to offer you a separation package if you sign the agreement today. That's when I knew they were rushing this. Legitimate performance terminations don't require same-day signature pressure. Companies with proper documentation are happy to let employees review materials because they know their case is solid. They'd slid the document across the conference table. I'd taken 41 minutes to read it thoroughly while they sat in uncomfortable silence. Most people would have felt pressured to sign quickly and get out. But at 51, you learn that taking your time isn't just smart, it's essential. Jerome checked his watch twice during my review. Rachel answered 3 text messages. Both behaviors told me they wanted this over fast, which made me want to slow down even more. The terms were standard. 27 weeks, severance 1 for each year of service. Health insurance through May. Standard non-compete clauses that would prevent me from working for competitors for 12 months. Non-solicitation language preventing me from recruiting Apex employees, and the non-disclosure agreement that would keep me quiet about the circumstances of my departure. What was missing was any attachment explaining the performance deficiencies that supposedly justified my termination. I signed it anyway, initialed every page, executed every signature line, because I knew something Jerome and Rachel apparently didn't know. Their own policy required PIP documentation for performance terminations, and by accepting my signature on an agreement that lacked those materials, they were documenting their policy violation. Some people might call that a trap, I call it holding people accountable for their own rules. Thursday morning at 8:33 a.m., I received an email from Noah Parker confirming everything I suspected. Mr. Hoffman, following our conversation last night, Apex Dynamics would like to offer you the opportunity to meet and discuss revised separation documentation that addresses certain procedural oversights in the original materials. Procedural oversights. Corporate lawyers speak for we screwed up big time. I forwarded the email to my attorney Felix Carter, who specialized in employment litigation and happened to be 53 years old. Felix understood what guys like us faced in corporate America. We'd met 3 years ago when Apex had hired his firm to review their employment policies, the same policies I'd written. The irony wasn't lost on either of us. "They're panicking," Felix said when I called him 25 minutes later. "They realized they terminated you without following their own procedures, and now they want to fix it after the fact. Can they do that? Not really. You already executed their agreement. They accepted your signature by processing your termination. Either the agreement is valid as signed, meaning they violated their own policy, or the agreement is invalid, meaning your termination is also invalid. So what's our next move? We go to this meeting and see exactly how deep a hole they've dug for themselves. But first, I want to do some research on their recent termination patterns. Something tells me you're not the only one this has happened to." Felix was right to dig deeper. Over the weekend, he made some calls to other employment attorneys in the area. What he found was disturbing but not surprising. 3 other law firms had been contacted by former Apex employees in the past 8 months, all claiming wrongful termination, all involving the same pattern of vague performance accusations without proper documentation. "Walter," Felix called me Sunday evening. "I think we're looking at something bigger than just your case. I've found at least 4 other people who were terminated under similar circumstances, all over 45, all high earners, all fired for performance issues that were never properly documented. Who are they?" Sandra Kim, 48, was a senior project manager. Terminated in September for failure to adapt to new project methodologies. No PIP, no written warnings, no specific examples. David Foster, 52, supply chain director, fired in August for inadequate stakeholder management. Again, no documentation. Then there's Patricia Wong, 51, and Michael Rivera, 49. Same pattern across all of them. The systematic nature of it made my blood boil. This wasn't just cost-cutting. This was deliberate age discrimination disguised as performance management. Monday morning, Felix and I arrived at Apex's headquarters at 9:55 a.m. We were escorted to a large conference room where Noah Parker waited with 2 people I didn't recognize, a man in his 50s who introduced himself as Richard Stone from Apex's outside counsel firm, and a woman in her mid-40s who turned out to be Amy Rodriguez, Apex's chief financial officer. The fact that they'd brought in outside counsel and the CFO told me this was bigger than just a documentation error. This was damage control at the highest level. "Mr. Hoffman, thank you for coming," Noah began, looking like he hadn't slept much since our phone call. "I think we can resolve this situation constructively. I'm listening." Richard Stone opened a tablet and pulled up a document. "We've prepared revised separation documentation that addresses the procedural issues with the original materials. The revised agreement includes the performance improvement documentation that should have been attached originally." "You created performance improvement plans after the termination," I said. Not a question, a statement. We documented performance concerns that had previously been communicated verbally. Felix leaned forward. "Performance improvement plans should be created and implemented before termination, not fabricated afterward. Creating them retroactively to justify a decision that's already been executed is not consistent with proper employment procedures." Richard's jaw tightened slightly. The documentation reflects genuine concerns that were communicated to Mr. Hoffman prior to his termination. "Then why wasn't it documented at the time?" Felix asked. "Why wasn't it attached to the original separation agreement as required by Apex's own policy?" There was an administrative oversight. An oversight that just happened to occur during the termination of a 51-year-old VP with 27 years of experience and a $315,000 salary. Amy Rodriguez spoke for the first time, clearly trying to move the conversation away from the legal minefield her colleagues were creating. "Mr. Hoffman, perhaps we can approach this differently. Apex is prepared to offer enhanced severance terms minus 38 weeks instead of 27, extended benefits continuation for 15 months, and a mutual agreement not to pursue litigation. They were essentially offering me an additional 11 weeks of severance, approximately $95,000 minus, to accept documentation that should have been provided initially. The size of the offer told me they knew they were in serious trouble. "What's in the performance documentation?" I asked. Richard turned his tablet toward me. 4 written documents from different Apex managers claiming various performance issues. I read each document carefully, taking my time while they waited nervously. The first document was from Mason Ellis, a director in supply chain operations. It claimed I had failed to meet efficiency targets in Q2 and Q3, but didn't cite a single specific target, metric, or measurement. No numbers, no benchmarks, no comparisons to previous performance. The second was from Nicole Johnson, a manager in quality control. She alleged I had shown poor judgment in budget allocation decisions, but didn't identify which budget, which decisions, or which outcomes demonstrated this poor judgment. The third document came from Carl Manning, a project coordinator who reported to me. He claimed I was resistant to new operational methodologies, but failed to specify which methodologies, when this resistance occurred, or how it impacted actual results. But the fourth document was where they made their fatal mistake. "These documents are completely generic," I said, pushing the tablet back toward Richard. "But more importantly, I noticed something else that makes your desperation even more obvious." I paused, letting the tension build in the room. Owen Mitchell hasn't worked at Apex for 8 months. He resigned last January to take a position with a competitor, 3 months before Jerome Walsh even joined the company. How is he providing performance documentation about my current work under Jerome's leadership? Richard Stone's expression froze. This was the moment I knew we had them completely. Mr. Mitchell provided the documentation based on his observations during his employment. Owen Mitchell left Apex before Jerome Walsh joined the company. He couldn't possibly have observations about my performance under Jerome's leadership, which is supposedly when these performance issues became termination-worthy. You're using testimony from someone who wasn't even present during the relevant time period to justify firing me. Felix was typing rapidly on his laptop, documenting every word. Mr. Stone, using a former employee who left the company months before the alleged performance issues as a witness, significantly undermines the credibility of this documentation. A jury would have substantial questions about why Apex couldn't find current employees willing to provide documentation critical enough to justify termination. Mr. Mitchell's employment status doesn't invalidate his professional observations, Richard said, but his voice carried less conviction now. Actually, it does, Felix responded, because it suggests Apex couldn't find current managers willing to provide sufficiently critical documentation. So they reached out to a former employee who has no current knowledge of Mr. Hoffman's work. That's not proper documentation. That's desperation. Noah tried to regain control. We're not going to debate the validity of the performance documentation. The offer is on the table. 38 weeks severance, extended benefits, mutual release. Mr. Hoffman needs to decide if he wants to accept it or pursue litigation that will be expensive and time-consuming for everyone. I looked at each of them in turn. Noah, nervous and sweating despite the air conditioning. Richard trying to maintain professional composure but clearly uncomfortable with the weakness of his documentation. Amy calculating financial exposure in her head. "We'll need time to consider," Felix said, standing. "Mr. Hoffman will respond to your offer within 72 hours. We left Apex's offices at 11:35 a.m. In Felix's car, he turned to me with a slight smile. "They're terrified. Did you see how quickly they tried to move past the Owen Mitchell issue? They know that using a former employee who wasn't even present during the relevant time period is going to look terrible in court. So what do? We investigate. We find out how many other people Apex has terminated for vague performance deficiencies without proper documentation. We build a pattern and practice case showing this isn't just about you, it's about systematic policy violations. Over the next 6 weeks, Felix's firm conducted extensive discovery through professional networks, former employee contacts, and public records requests. What they found was even more damning than we'd expected. In the past 18 months, Apex had terminated 31 employees for performance deficiencies. Of those 31 terminations, 24 had been classified as requiring performance improvement documentation under company policy. Of those 24, only 6 had actually included attached PIP materials at the time of termination. The other 18 had been fired without the required documentation, just like me. Most of those 18 people had signed separation agreements and left quietly. They were overwhelmed by the termination, worried about money and health insurance, and finding new work. They didn't have the energy or resources for a legal battle against a corporation with deep pockets. But 6 had hired attorneys and filed EOC complaints alleging age discrimination. 4 had settled confidentially. 2 cases were still pending. More importantly, Felix discovered a pattern that made the entire situation even more disturbing. Nearly every performance deficiency termination had occurred within 14 months of Jerome Walsh joining Apex's leadership team. The average age of terminated employees was 49.2 years. Their average tenure was 16.4 years. Their average salary was $127,000, well above the company median of $78,000. Jerome wasn't just cutting costs. He was systematically targeting Apex's most experienced and highest-paid employees, manufacturing performance allegations to justify what was really age and salary discrimination. Felix also discovered Jerome had done this before. Court records showed he'd been named in 4 wrongful termination lawsuits at his previous company, all alleging he'd fired experienced employees on fabricated performance accusations. 3 cases had settled confidentially. 1 had gone to trial and resulted in a $650,000 verdict against his former employer. But the smoking gun came when Felix's firm subpoenaed Apex's internal emails as part of the discovery process. What we found in those emails revealed the deliberate nature of what had happened to me and dozens of others. 3 weeks before my termination, Jerome Walsh had sent an email to Rachel Turner and Amy Rodriguez with the subject line Q4 Cost Reduction Strategy. The email read, "We need to reduce operational overhead by $3.2 million before year-end to hit board targets. Recommend targeting senior operations staff with highest compensation packages. Walter Hoffman, $315,000 base plus bonus, is top of list. He's resistant to the new efficiency initiatives anyway. Let's move quickly. What's the cleanest termination path?" Rachel had responded, "Performance-based termination requires PIP documentation per policy section 7C. We don't have current PIPs for Walter. Creating documentation now would take 90 to 120 days minimum." Jerome's response, "Don't have that kind of time. Can we use past performance reviews or general feedback from managers?" Amy had chimed in, "Legal will want something in writing to justify performance termination. Can we get managers to document recent concerns retroactively?" Rachel's final message, "I can reach out to Mason, Nicole, and Carl for written statements about performance concerns. Also checking with Owen Mitchell. He worked with Walter before and might have useful feedback." Jerome, "Perfect. Get those statements and let's move forward. Keep this tight. Don't want him getting advanced warning." That email chain proved several critical things. First, my termination wasn't about performance at all. It was about cost reduction. Jerome needed to cut $3.2 million from the operational budget to meet board targets, and firing senior staff was the fastest path. Second, they knew they were supposed to have PIP documentation. Rachel explicitly mentioned the policy requirement, but instead of following proper procedures, they decided to fabricate documentation after the fact. Third, they deliberately tried to keep this quiet and move quickly to prevent me from defending myself. When Felix showed me those emails, I felt vindicated and disgusted simultaneously. Vindicated because it proved everything I'd suspected. Disgusted because it showed how little Apex valued the careers they were destroying. "This changes the case significantly," Felix said. "This isn't just policy violations anymore. This is deliberate fraud. They knowingly terminated you without proper documentation, then tried to fabricate documentation afterward to cover their tracks. We amended our complaint to include the email evidence and add claims for punitive damages and age discrimination. We increased our damages demand to $2.1 million and reached out to the other terminated employees to explore a class action lawsuit. That's when Apex's settlement offers got serious. Within 3 weeks of filing the amended complaint, Richard Stone called Felix with a new offer. $1.4 million, no confidentiality clause, written admission that my termination violated company policy, and agreement to implement comprehensive age discrimination training for all executives. "They're panicking," Felix told me. "Those emails are devastating. No jury is going to side with Apex when they see executives openly discussing how to circumvent their own policies to fire someone for budget reasons." But I wanted more than money. I wanted accountability. "What about the others?" I asked. "Sandra Kim, David Foster, Patricia Wong, Michael Rivera, they deserve compensation too." Felix smiled. "I was hoping you'd say that." I've been in contact with their attorneys. Apex knows they have 18 other cases with similar fact patterns. They're looking at massive liability. We negotiated for 2 more weeks. The final settlement included $1.4 million payment to me, establishment of a $2.8 million fund to compensate the other improperly terminated employees, written admission by Apex that systematic policy violations had occurred, mandatory age discrimination training for all executives and managers, an agreement that Jerome Walsh would resign within 60 days. The written admission was crucial. Most settlements include no admission of wrongdoing, but the email evidence was so damning that Apex agreed to admit they'd violated their own procedures systematically. 6 months after the settlement, I received a call from my daughter, Emma. She was in her 3rd year of medical school now, and I no longer worried about affording her tuition. "Dad, I heard about your case in my healthcare law class." The professor used it as an example of how employment documentation requirements protect both companies and employees. She said, "You basically wrote the policy that saved your own career. I'm proud of you. That meant more to me than any settlement check." Linda had been right during our late-night conversation after my termination. This was about more than just me. It was about protecting experienced workers from predatory corporate executives who saw age and experience as liabilities rather than assets. 9 months after the settlement, I started my own consulting firm helping companies develop proper termination procedures and age discrimination policies. My experience at Apex became a case study I use in presentations about why documentation requirements matter and what happens when they're ignored. The lesson isn't just about reading your employment agreement carefully, though that's important. The lesson is about understanding that employment policies exist for a reason. When I wrote that performance improvement documentation requirement 8 years before my termination, I was protecting future employees from exactly what happened to me and 18 others. By the time Apex realized their oversight in not attaching PIP materials, they'd already accepted my signature on an invalid agreement. That oversight cost them approximately $4.7 million in total settlements, legal fees, and restructuring costs, all to save $3.2 million in operational overhead. Sometimes the best revenge is simply making people follow the rules they agreed to in the first place. The most dangerous employee to fire isn't the one who screams or threatens lawsuits. It's the one who quietly reads every word of what you put in front of him and knows exactly what those words mean. Because when companies get sloppy with their own policies, they're not just breaking rules, they're handing you the weapon to destroy them. At 51, I learned that the policies you write today might be the only thing standing between you and corporate betrayal tomorrow. So write them like your career depends on it, because someday it will. The real victory wasn't the $1.4 million settlement or even Jerome Walsh's resignation. It was proving that experience and institutional knowledge are weapons more powerful than any young executive's ambition when you know how to use them.